Yes.
I think for person.
You are for the
I
petitioner.
was petitioner.
Have you served?
Yeah, absolutely. Court's watch is 10 minutes past.
10 minutes?
Yeah, we have.
Can't
My
be.
watch shows it's 55. Oh, I'm sorry, then I'm wrong. My watch says it's 155. My lord.
Huh? No, no, take it. Pass, pass. Something left. Something left.
No, everything's done. Everything is done.
Yes, evident.
I think it is very for the petitioner.
Yes, yes.
Very comment short father.
What is the matter about?
Ashok, the matter is very. The petitioner therein has filed an application under order 39 rule 7
Yes, sir.
for appointment of commissioner along with an application for carrying out repair.
Hmm.
The application was heard by the London trial court, and after that, the said application was rejected on the ground that the trial court has observed that the requirement which was asked for in the said application under order 39.7, the questions that were suggested by the petitioner does not require, cannot be adjudicated by an advocate commissioner, and a scientific expert has to be appointed instead. So challenging that order by the London trial court, the petitioner again has approached this honorable court of action.
And who is for the other side? Have you served?
The applicable service has been filed, Your Worship. This purely relates to question of law, Your Worship.
What? Is this one is not going to see system accommodation. Affidavit of
Affidavit for the commissioner of the applicable service has been filed.
where? Oh, yeah, affidavit service is it? No, no. No, obviously, I think. It's not today. Not today. No, affidavit service was not yet come. Ah, yes. Let it come tomorrow.
After the indulgence of this honorable court, the authority concerned was pleased to register my, yes, they did.
Registered. So no further.
No further. But my lord, I have a small prayer to make here, subject to your lordship's acceptance. Now, here there is a lot of confusion.
Yes.
My lord, here in Andaman, there is a lot of confusion looming around with respect to adoption. Now, what happened is after the registration of the deed of adoption by the concerned authority, when I approached the birth and death register, they are saying that there has to be an order from the side of the deputy commissioner. Now, I don't know what deputy commissioner has to do with this. If it was under CARA guidelines, then deputy commissioner had something to do with it because he is the ultimate authority who will pass the final order. But in case of a registered deed, that is the final legal document to show an
For registering the name of the adoptive parents.
my lord, in the birth certificate. Though it is not the subject matter,
To register.
but a short observation, it may be made so that all the authorities in these islands take the registered deed as the final document.
Respondent has represented. So it is the learned advocate for the petitioner that the deed of adoption, which was sought to be registered, has already been registered by the authorities. stop the, no further, order need be passed in the present proceeding. Hmm. Para, four again. It is expected that the authorities will act in accordance with, on the basis of the deed. That will do.
But should let there be an observation saying that
I said authority will act in accordance with the.
that's what they don't want to understand. When I say in terms of section 16,
We to go for it in circumstances, WPA certain such, is disposed of. You will again, come back with including the commissioner, dispose of.
my lord, I already did two other matters earlier. I mean, that's what they're doing. Once this honorable court directs, then only they will do it. Otherwise, they won't. That's what the, in spite of having a registered deed, I don't know why they are not doing it.
In this matter, particular, in this matter, it's for only for registration of the adoption date that has been done.
That is. I have just said that, the authorities will act on the basis of such deed.
Deeply obliged. I'm grateful.
This lordship is the last petition has asked the petitioner to serve a copy of the.
Not in this. Sarana Kumar. Isme.
This was, petitioner will serve a copy.
I'm there.
Yes.
सरना में ऐड होने बोला ना हेलो ऑथोरिटी को दे दिया बहुत दे दिया
Yes, sir. Have you served?
I have served. I am giving a spare copy also. Authorities have been duly served on 1st of August. I am giving a spare copy to the GP also. On 1st of August, service was effective.
When you were supposed to file your affidavit of service.
Madam is appearing, Lord.
Occupancy. Yes, not. Plus, imprisonment of self. Yes, madam.
Well, I appeal on behalf of Congress.
You want to file affidavit? What have they done?
The authority should have turned down the application for demarcation at page 30. But there is one more matter coming up where I have been asked to add the parties to the suit in the present date. So here the Sarana Kumar. Identical, because similar order was passed by Justice Court number 1. I relied upon those orders. The order was tested before division bench. It's an affirm. The suit is pending. Status quo is operating. But in one case, identical case, have asked me to add those parties in. Who are the party to the suit in this? I will add them in this also.
In this also.
Appearing on behalf of the added respondent. No, I'm not serving the government.
Because it is yet to be added.
Then wait, they need to wait. They are taking the notice.
Yet to be added.
Now.
You have not been added. Petitioner and respondent are represented. Stop the on the prayer made on behalf of learned advocate for the petitioner. Liberty is granted to the petitioners to implead all the parties of pending title suit. Respondent administration is appearing.
Only the official respondents are parties.
Yes. Next, the petition shall serve upon the added defendants and file an affidavit of service to that effect on the date fixed. So the petitioner is also granted liberty to make necessary amendment in the first title. Uh, is the matter on?
Let it come on Friday, let's see, if time permits, I'll bother to. Otherwise, it can be taken from the next. Let it come on Friday. Let me see how far I can serve it in the meanwhile.
Is the matter on Friday? Friday. Friday, 4th तारीख को June the first 8th. Nobody. Item 6. Punjab, superintendent engineer, assistant engineer. And appears for the parties for it. Calcutta is the matter. हाँ. अच्छा. आज के 4 ना? आज 4th, तो 5th.
Right, for the petitioner, I've already served copy here, all the respondents. Anybody is appearing or not? There are 3 respondents. One is Honorable Lieutenant Governor, and then Deputy Commissioner and Assistant Commissioner Headquarter. And since I'm insisting for an interim stay, Your Lordship, therefore I have to argue the matter.
Interim stay of
The operation of the impugned order, by which I have been asked to cease my work immediately after 15 days of the passing of the order.
work.
I'll place my facts, Your Lordship. Here, Your Lordship, the petitioner happens to be having a business at Car Nicobar, where he is running a automobile repair as well as servicing center.
Operation of Mrs. Shotto Auto Service.
Yes,
It will cease after if the proper registration not obtained under the Shops and Establishment Act.
yes.
Uh,
No, I'll just come. I'll place the facts, Your Lordship. The petitioner, who happens to be a businesswoman, she's running this. Normally, this is Babita Das appears for the.
Friday. Yes.
So meanwhile, I should not be disturbed, Your Lordship, because there are 16 persons who are under me.
They are not there. How can I pass an order behind their back?
Lordship, but I have to play. There is an extreme urgency, Your Lordship. Let it be tomorrow. I think that instruction can be.
Day after?
There will be a delay, Your Lordship, because Your Lordship may kindly read the order. Order where how I am affected. I can serve a copy to my learned sister today itself. Let it be taken up tomorrow, Your Lordship.
The petitioner is represented. So none appears for the respondents. Usually,
Miss Babita Das,
Ms. Bobita Das appears for the
administration.
session, and she is present in the court. So she submits that she has not yet received the copy of the petition from the department. Copy of documents or any instruction from the department. Stop here. The advocate for the petitioner is requested to make over a copy of the petition to this Das. study this matter on day after tomorrow, 6th.
6th, Your Lordship. In that event,
She will be,
in that event, I will be using one supplementary affidavit, Your Lordship, because there are certain developments this morning. So I will be using a supplementary affidavit, bringing those things before.
liberty is granted to the petitioner to use a supplementary affidavit.
I'll supply a copy in advance to my learned sister.
6th. Yes.
My lord, I appeal for the petitioner, my lord. The affidavit of service already filed, my lord. इसमें है unknown recovered.
Only official respondents. Only official respondents.
My lord.
Copy. There is no proof for any increase or I can do that.
Petitioner and the official respondents are represented. So they on the prayer made on behalf of learned advocate for the petitioner, for the respondents. Let affidavit in opposition be filed within 3 weeks. Within, then it will go out of the next circuit also. One, they will be seeking what? 2 weeks from that?
Yes.
So the reply if any, within 1 week thereafter. This the matter before the next resolution circuit.
Acknowledge, my lord.
जिला पर से यार यार टमाटर जिला प्रश्न not an and there, Lord. Lord, I have done certain works which were awarded to me. The work was in and as per this stipulation, as per the authorities. I have to raise a playground. I have did it. The amount has not been released.
Why?
No reason, nothing, no decision taken. I have been making.
You have raised the bills.
Yes, yes, everything was done.
Yes,
Everything
sir.
was done. North and middle number.
Non-payment of for the work carried out for construction of CC stage in forest ground, oral Calcutta. So you want
Affidavit was disclosed what the reason for why.
when?
Quite question of whether the work was done or not done has to be explained.
Petitioner is represented. So the next one, learned advocate for the official respondents seeks to use an affidavit. Let affidavit in opposition be filed within 2 weeks from date. Reply
1 week.
Within a week thereafter. This the matter before the next.
Just one line, Lord. Filing of affidavit of service may kindly be dispensed with. Since the respondents are appearing, they have accepted notice. The filing of affidavit of service may kindly be dispensed with.
Since only the official.
Only officials. 3 numbers.
Since,
3 numbers.
Since all the official respondents are already represented. Filing of affidavit of service
Maybe
is dispensed.
I'm grateful.
Petitioner, I'm appearing on behalf of my senior Anjali Raghunath.
Actually, she's in the court, room number 1.
And who is for the other? And who is for the other side?
I'm giving respondent number 2.
Respondent number 2.
But they want an implementation of an order, petition or task by the sub-divisional magistrate. This petition won't right, they have to come as an, state to be also issued notice, but sub-divisional magistrate can actually
State not made a party.
not pay as a party. True, the public
There is-
prosecutor he has to be attained.
That is when the respondent authorities, especially to install soundproof generators.
They want an implementation, they want the proceeding pending before the sub-divisional magistrate has to be. Proceeding has to be concluded.
No.
Yes, sir. Prior C, prior B.
They have the edit in the subdivision and want to conclude the proceeding which was
Minister to conclude the proceedings, which was initiated under 151.
133 of the.
CRPC, bid petition is not. So they have to come with the revision. This is the view 152 is specifically.
Under 133 is a judicial proceeding, which is not amenable to read jurisdiction. Either you have to amend the cost title and leave out the second prayer.
Yes, sir. State to be as a, no public prosecutor has to be.
Passed over. But there are hardly any matters.
And for the respondent, I also.
I'm praying for some extension for filing AO, my lordship. As a last chance, maybe it may be treated, my lordship.
You are for respondent?
Official response, 1 to 3, my lordship.
1, 2, 3.
There are,
for the petition.
there are 3 respondents for all I am representing.
Last time also.
Yes, my lordship, but it is going for vetting, my lordship.
Before that as well.
I do agree, my lordship, it is. And the parental agreed.
Official respondents are represented. Is there any private respondent?
No, madam.
Only.
No, ma'am, all are official.
On the prayer read on behalf of Chartered Advocate for the respondents. Commonly, time to file affidavit of position is extended by
Arunesh Kumar, my lordship. Led by Mr. Vidish.
when will you file?
Within 10 days, my lordship.
Extended by 2 weeks. Reply if any within 1 week thereafter. Is the matter before the next available.
Problem, my lordship.
This honorable court on the last occasion has passed an order to file an affidavit and also furnishing the details of his provisional pension.
Petition.
Twelfth of June.
But it is, because since extension of time to file affidavit, in affidavit will enclose his details with regard to the.
Subsequently, the referee floated for the tender and located approves to different individuals. Was there any pending disposal of the petition, the provisional pension may be released to the petition? Provisional pension release.
I have to ascertain the options. That is the next step, it means when it furnish the details.
Parties. Is the matter before the next available circuit, when the respondent shall file his affidavit in opposition.
Obligation.
My lord, I am appearing for the petition.
And who is appointed you?
And at the last occasion, the respondent filed the report, the shape of an affidavit. I filed the reply also. Today.
Oh, yes. Okay, we will submit to the report.
It is ready for you. My lord, kindly come to page number 15 of my writ petition, the allotment order. Page number 15, first document. Order number 243 dated 28 April 1969. The name of my father is appearing at serial number 13, next page, page number 16. Mahendra Haldar, son of Kailash Haldar. So by this order, allotment order, the land measuring an area of 2.02 hectare situated at Manglutan village has been allotted to my father. Thereafter, the record has been finalized, which is at page number 17. It is the record of rights for the holding register.
Finally published.
Yes, this is the record of right. Page number 17. Name of my father is appearing in column number 3. Mahendra Haldar, son of Kailash Haldar. Then over non-occupancy right land. Survey number is also mentioned 1 by P. Area 2.02 hectare. Allotted last right hand side allotted by deceased order number, SDU's order number 243 dated 243, 28 April 1969. So this is the finalization of the fund. Next page is the map, sketch map. 1P is appearing, one survey number is appearing 1 by 22 and surrounded by land bearing survey number 1 by 2. Sketch map.
Next page.
Next page. The sketch map. 1 by 72. That is allotted land in the name of my regularized land in the name of my mother. But the allotment land allotted under the scheme 1 by P, that is surrounded land. Now my father died in the year 1986. Next page is the death certificate. Once the record of the land has been finalized, so I am liable to pay the land revenue also. Page number 20 is the receipt for land revenue. I have paid the land revenue also. It was accepted. Survey number is clearly mentioned, survey number 1 by P. In the name of Mahendranath Haldar, that is my father. Now, next document, I asked for the record entry, page number 21, issuance of record entry and sketch map of land. I made an application to the deputy.
Sketch map. In record entry and sketch map.
Yes,
And what is this at page 18?
page 18 is the sketch map of the land.
And which sketch map you are talking about in this application?
1 by P. Survey plot number 1 by P.
1 by 2. So sketch map was prepared.
Sketch map was prepared with respect of survey number 1 by 20.
1 by 22. What I am submitting, that this land bearing survey number 1 by P, which was allotted to my father in the year 1969, this 1 by 22 is surrounded by that land. What is their submission? That this 1 by 22, 72 has been, number has been bifurcated from the same land. But my submission is this is a different land. It has been regularized. This land was regularized in the name of my mother as per the settlement scheme of 1987. It is regularized land. Now, I have submitted an application. First, Deputy Commissioner. Second, the Tahsildar Farhad and Tahsil, because this land is situated within the jurisdiction of Farhad and Tahsil. request for issuance of record of right and sketch map of land bearing survey number 1/P area such and such. So it was not provided to me. But I have been asked to file application to the Assistant Settlement Officer, Survey and Settlement, because at that point of time, the resurvey was going on in that village. So I filed another application, page number 23, on 19/8/2024. Same request for the issuance of record of right and sketch map of land bearing survey number such and such. Even the Assistant Settlement Officer did not provide it. Now I'm coming to my application under the Right to Information Act, page number
24.
24. I have asked for the certified copies of note sheet and action taken notes in respect of my application for issuance of record of right and sketch map of land bearing survey number 1/P, area 2.02 hectares situated at Mangutan village under Prayagraj Tehsil, recorded in the name of my deceased father, late Mahendranath Halder, submitted by RD number such and such.
And according to their report, there was
No
existence of such land.
No land.
It's 1
When
by
I am
22.
having the allotted land,
1/20.
22. Says
1/22 is regularized.
allotted
My
and
mother,
subsequently-
no, that is not your reply notes. My mother enclosed the adjacent land prior to 1978. Because as per the scheme of 1987,
You want another land settled in the name of your mother.
that has been already been regularized and allotted. There is no problem.
Two
there is no
survey
problem.
numbers are also allotted.
1/P, let me
Mahendranath
complete, let me
Halder.
complete. 1/P has been allotted in the name of my father, Mahendra Halder, in the year 1969 by allotment order number 243.
243.
243. Now, the adjacent land, government revenue enclosed by my mother prior to 1978. In the year 1987, the Home Ministry invented a scheme for regularization of the enclosed land who have committed encroachment prior to 1978. Under that scheme, my mother filed an application for regularization of her encroachment.
And that has been
Under
regularized.
that regularized. That is the survey number 1/70.
22.
Sorry, 22, sorry, 22. So that is a different land. And regularized under this 1987 regularization scheme. That is a different land. But when I asked for the land which was allotted to my father and record has been finalized, even ROR has been prepared, the land revenue I have already paid. I am asking for that landed property. Now they answered that as per information received from Patwari
Where
Mangutan
are
village.
those documents that some certain lands were settled in favor of your mother? Where are those documents? The documents with regard to settlement of land in the name of your
Sketch
mother.
map it is written.
Huh?
Sketch map it is written. That is sketch map which I have shown.
You must have been.
It is shown. Land survey number 1/22 area such and such situated at Mangutan is stand recorded in favor of Srimati Manoda Halder, who is the mother, wife of late Mahendra. That is different land.
That was prior to this settlement.
No, after that. It was done in the year 1989. Scheme came in the year 1987.
And this
And allotment 1969.
and your father's allotment was in the
1969.
69.
69.
Encroachment was done by Mahendra Halder. I have got
No.
the document to show.
No.
Document is there. Let me kindly see, I'm just handing over the set document.
Maybe
Maybe
my husband enclosed the land. Subsequently, I have continued in
he
possession.
expired, so it's.
I am in
regularized
continued
the name
possession.
of Manuda Halder.
That
is
has
fine.
been regularized in my name. But what about the allotted land? That land is still in my
Now you
occupation.
just submitted that the land has.
But no
been
document you have
encroached by
supplied to me.
Mahendra Halder.
That
But the
document is
fact
not.
is that Mahendra Halder is.
When my father expired in the year 1986,
And that was
86,
allotted, and that is.
my
survey
mother-
number 1/22.
mother remained in possession.
This is the
What you are
true fact.
submitting? And what you have stated,
This
your
was the settlement in favor of the mother.
mother.
Since he expired, he has encroached, Mahendra Halder, he was an encroacher and he has encroached certain portion of land, which was subsequently regularized in the name of the, Manuda Halder since he expired in the meantime. So, license issued in the name of Manuda Halder.
Under the
My lord,
87
kindly
scheme.
see 1/22. So, my lord, 1/P survey number which they are harping on, now it has been bifurcated and it's 1/22. There is no such survey number as 1/P at
P.
present.
Then what about the ROR prepared?
That was long.
Now,
back
what they have
where
stated
after
in the
that
reply,
was-
report, that is different.
And
What they have stated, let me
Uh,
complete,
the
I am the petitioner, let me complete.
Now
my-
the survey number is 1/22, which has been regularized in favor of Manuda.
Okay, you
Halda.
make your submission. Submission.
My lord, I have just handed over the document, my lord. It's the name of the
me a
enforcer,
copy.
my lord, it's a Manuda Halda.
Give me a copy.
Since I have been asked only to file a report, my lord, it's very precise. So if my lord, can grant me time to file my opposition so that annex all the documents, because I was asked to prepare a report only. Submit a report only, so it's very precise. The report is very precise.
That was the thing you asked for.
No, my lord, no, I didn't ask for any filing of report. I asked for filing my opposition, but
You'll get over a copy of this.
mine.
My lord, kindly come to the report submitted by them. What they have stated, they are admitting the allotment in the report. Now denied. In their report, they are admitting. Even in paragraph 3, page number 3 stated that during 1989, the
That was
petition of family
subsequently
and.
has been allowed,
Let me complete, madam. Why you are shouting?
It's the same
It
land.
is a family occupied land with survey number 1/22.
Yeah.
It is a different story.
So the, in,
Two more survey numbers are there which have been allotted in the name of Mahindra, Alda, same village.
it is submitted on behalf of the advocate for the respondents that earlier she was asked to file a report in the form of a affidavit, which she did. So the, she, however, speaks here, file an affidavit dealing with the allegations in the writ petition. So the learned advocate for the respondent also relies upon what is this?
This is a record entry, it's extract from record into register,
Extract from land records.
land records.
Land records. So a copy of which is handed over to learned advocate for the petitioner. Madam, I
So,
mean.
That's from enforcement register. I think.
Enforcement register.
um,
Work of that. Take copy. Take copy.
Details of the HPC. HPC,
High power committee.
that it must be an enforcement register.
Enforcement register.
Enforcement registered. A copy of which
No, I'll annex all those documents in my opposition.
then
Mine.
please hand over this to
Yes.
your learned friend.
All the documents are annexed with even the mutation proceeding also. It's-
Is handed over to learned advocate for the petitioner in court. Next paragraph, let such affidavit be filed within a week.
Mine.
Within a week from the reply is within 3 days there. 3 days thereafter. Take the matter before the next available jurisdiction. Yes, sir.
Against the report submitted by the authority.
That has not been taken on record.
I have filed today.
Today, then for first line and affidavits filed and could be taken on record.
From 3 to 6,25.
And for the response.
All of them. State proceeding. Yes, madam, you were there. Have you filed the affidavit?
Required, my lord.
I'm appearing for the petitioner, Your Lordship.
Last,
The respondent authorities have informed me.
last time it was,
Yes, I think to take instruction, my lord. I think I have submitted that, they're going to vacate that eviction order. So this is the vacation. order. The same day it was vacated.
That has been cancelled.
Your Lordship, based on this order, this petition be disposed of.
Repetition.
On the basis of this order, wherein the stay has been vacated, wherein the eviction order has been vacated, on the basis of this order of the respondent authorities, I pray that the petition be disposed of.
The election notice of by the Tahsildar till the disposal of the
Yes.
suit. Petitioner is represented. Learned advocate for the official respondents. Submits. And order dated, order passed from July 14, 2025. By the Tahsildar.
The impugned order is 30 June 2025.
30th June.
Your
Yes,
Lordship, 30th June.
On,
14 July
Passed
order
by-
was passed by this court.
Tahsildar, and against which they have filed this writ application, my lord. And my lord has passed an order on 14/7/2025, my lord,
that's
the interim stay. And on that day itself, my lord, the,
No, this order is passed on 14th of June, July.
yes, my lord, and on 14th of July, my lord has also passed staying that operation of that eviction order. That day thereafter,
Thereafter they are.
yes, my lord, thereafter.
Uh, by the Tahsildar Faragganj. Stating inter alia that the eviction order passed by the Tahsildar on July 14th. That was also
30th June.
passed on June 30, 2025, has stood cancelled. Studying in circumstances, no further order is required to be passed when the present writ petition. Study accordingly to the WPO.
One line may be added, my lord, the order dated 36/2025 in connection with RC case number.
Oh.
We mentioned, my lord, in connection with
Uh,
RC case number 270 of 2025.
30th of June, 30.
Yes, my lord, 30th of June it was written.
In connection with RC case number 270 of
Yes.
2025.
Right.
Wait, okay. You can see. Since disposed of.
Now,
Obliged, Your Lordship.
One for the appellant to play guilty. This court passed the order more value consider that.
I am appearing for the respondent. I want to file objection to the stay application.
Stay application.
Order dated 14 July 2025, may kindly be seen. And 1 of 2025 being the stay application was considered. Interim protection for limited period was granted.
The plaintiff served a copy of the stay application upon the defendant within 3 weeks from the date. The matter shall be listed after 3 weeks before the next available circuit. Since the plaintiff has been enjoying order of injunction since the defense of written a third party in the trial and the refusal of you, now the same should continue for the further period of 6 weeks from date. You want extension?
Yes, if they file opposition, it has to be accepted.
That has to be.
No.
And the opposite part, the respondent. are representatives of the learned advocate for the respondent seeks to file an affidavit against the stay application filed on behalf of the petitioner. Let such a next paragraph, let such affidavit be filed within
2 weeks, automatically it will go to next cycle.
even 1 week will take it to
2 weeks.
2 weeks from there. Reply is any
1 week there.
1 week thereafter. Is the matter before the next available circuit. Stop here. The order of stay granted by order dated July 14, 2025 is extended extended till August
25th is the next circuit.
31st August.
31st August?
Well,
August 31.
obliged.
But 3 weeks would take us to the,
Next,
will not take to the next.
Then my lord, 10 days time is sufficient for me.
Because 3 weeks is counted, my lord, it would take
then,
next week.
10 days. Affidavit in 10.
Section of the interim order will extend it till 30th September. Or
My lord, kindly shorten the time, my lord. I will file it in 2 weeks.
an appropriate order. If earlier made.
My lord, the time may be shortened so that it can be taken up in the next cycle. Otherwise, it will go.
2 weeks,
10 days.
10 days probably. And
1 week.
1 week.
Obliged.
Extension up to 30th.
Agreed.
For further order, you feel whichever is earlier.
But this matter has a checkered history. Before I could place those checkered history, an order of this court needs to be seen.
Long matter.
It could take, but kindly consider order dated 10th April 2025.
Then I'll not go into the
But kindly see the order dated 10th April 2025. We filed the affidavits
10th April.
10th April by His Lordship Honorable Justice Tapabrata Chakrabarti. Upon affidavit, he exchanged this order came to pass.
Property. As for the scheme of regulation dated 15th of June 20, the excess area cannot be located on the. They are not included for education, the same as nothing but.
So they have to bring this exhibit 3, authorities have to bring this exhibit 3 by way of a supplementary affidavit. Till now, they have not filed it. If they do not file it, let them raise their hands. I will proceed with the matters which is already on it.
Yes, sir. When order has been passed, it has to be carried out. Hmm.
2 days time may be given, my lord.
In my affidavit, I have specifically stated there is no existence of exhibit. Even that order was passed by the deputy commissioner, that was challenged by me before this honorable court. In that order, it is only I cite written that exhibit 3 has been considered, but there is no exhibit 3.
These arguments.
So that order which was asking by the petitioner, that order was set aside by this
So
honorable.
those things was considered, then this order came to pass.
But this order quotes earlier order passed by the trial court, which says that it was considered,
This has to be brought in record.
considered
Yes.
by that court.
The authority have to
And it
bring
has
it.
been considered by this court in my writ petition and
They have to
the
bring
order
it.
passed by the deputy set aside. That there is no existence of exhibit 3.
Petitioner, the official respondents and you are for the
For private respondent.
and the respondent are represented of the learned advocate for the petitioner points out that order dated April 10, 2025 has not yet been complied by the official respondents. Stop you. That's the learned advocate representing the official respondents seeks 2 days time to comply with the order. in this order in respect of production or filing of supplementary affidavit annexing the exhibit 3
As referred to an order dated 1 July 2016, Your Worship.
yes, first, exhibit 3, referred in the order passed by learned trial court.
By the Deputy Commission.
That order was passed by the trial court first,
No, by the authorities.
by the authority,
Authority, respondent number 2.
by respondent number 2 on July 1, 2016. So, next paragraph, there is the law. So, list the matter on Friday.
Day after tomorrow. Friday or day after, as once they file it, Your Worship.
Maybe on Thursday, my
No,
lord.
they will file only
Huh?
report. I know.
Thursday, my lord.
On Thursday.
Thursday.
Thursday, 7.
6.
Is the matter on 7. When the supplementary affidavit will, when the private official respondents shall file the supplementary affidavit.
My lord, if there is no report, let them file a report that exhibit. If there is no.
It doesn't lie in the private respondent's mouth.
No,
Let authority say
let
so.
them file a report that no
This
document.
doesn't lie in the mouth of the
I
private.
know that there is no
There is
document.
already,
can say?
there is
What
already
say?
an order, but they will file
Already
supplementary.
an order, they have to produce the exhibit 3.
Yes.
But I know there is no existence of
It's
exhibit.
there, I can show it.
So if not,
try to
let them file a report to
The
them.
person in
Yes.
whose custody it is, he is not saying anything.
Yes.
We will try to.
He is not saying that I don't have.
If it is not available, then I will take it.
He is new in this matter, but since the beginning, I am, Mr. Jaipal is doing this matter, so we are aware of the fact.
70.
Item 17, number 254.
17. Hey, please.
1 day's accommodation. I have already prepared the reply.
You're for the,
Petitioner. For vetting, my client's vetting is there. I will file it tomorrow so that this can be taken up. Lord. Just 1 day second. Tomorrow let it come.
on the prayer made on behalf of Learned Advocate for the petitioner, list the matter. So there is official respondent is representing.
I'm extremely aware.
My lord, I appear for respondents number 4 and 5.
My lord, for Google India, I have filed my affidavit of opposition. But the difficulty lies with me is that the address of the petitioner is not proper in the writ petition. If I can get the email ID of the petitioner, I can send through the email.
Those are the petitioner.
Petitioner is appearing in person notice. No,
For respondents number 4 and 5, my lord, we have also filed our affidavit in opposition and have been unable to serve for the same reasons.
And who first appeared for the petitioner?
he appears in person, my lord. He's there in the screen.
Seventh January 2024. What was the order on 7th January? That the petitioner take approval from this, the petitioner saying taking like long between knowledge regarding the implementation of agricultural proceeding. I don't know to compass detail, so mentioning it, no matter
How one के लिए?
will it be a long matter?
My lord, we have objections on maintainability itself.
Maintainability we have challenged in the very first day.
The other,
Since there was a direction for filing affidavit of opposition, I have filed today. But since the petition is there in the screen, if he can give his email ID, I'll send through
petition.
mail ID. He's
Yes,
present.
sir. Petitioner. Mr. Paul. What is the matter about?
He was running a YouTube channel that was banned by the concerned authorities for that reason.
By respondent of 4 and 5.
He says it is,
No, my lord.
he says that it was done by Google India in the petition. He says it is done by the respondent number 2, 3. So it's including everybody.
My lord, no prayers have actually been sought that can be enforced against respondent number 4 and 5. We are private entities. Respondent number 4 is a producer of the film Jawan.
Ban that particular channel.
And what is the document that shows it has been banned?
My lord, there is an email which he has annexed to the writ petition.
Is at page number 57, 58, my lord.
57.
Yes, my lord.
You currently have one more copy of this which is the claims of the mathematics subjective attention. We remain live for 7 days after we receive it for the strike. It's safe resolution and keep the exam. Then he is not responding. Mr. Paul, can you hear me? Yeah. No. He has gone offline.
Yes.
My lord, also in an identical case, the Supreme Court has held that private entities such as YouTube, Google India, they are not amenable to the writ jurisdiction. So on that point itself, this writ petition should be dismissed.
That is the maintaining issue that has been raised by the other.
Moreover, my lord, we are not the authority to ban any channel.
You are for Google India.
My lord.
Then where did he get that email from?
My lord.
Where did he get that email from?
That he has not enclosed. He has only responded to what he has responded in the mail. He has enclosed that. When the channel was banned, he responded in the mail. That's all. And the difficulties, my lord, I'm sorry to interfere. The petitioner, he is residing at Delhi. He has given the address of Diglipur, Andaman. So we are unable to serve the copy of affidavit opposition also.
Although appeared on the screen to virtual mode, but he could not be contacted. When the case was taken up for consideration. So please, and next for okay for you are for
Respondent number 1, my lord.
respondent number 1 and
4 and 5.
you have also not been able to serve.
No.
And you, madam?
No, she's
For
I'm for respondent number 4 and 5. That's my colleague who's there in person.
the other respondents, some that they have not been able to serve upon serve the copy of the affidavit in opposition.
Yes, my lord.
From the petitioner. So it has been played that the petitioner be directed to supply his email ID.
My lord.
So that the affidavit in position be served upon him. So next one upon repeated attempts from the petitioner did not respond to the calls made by the court, though he was visible on a screen. Keeping it on Friday.
My lord,
Yes, Your Honor, it provides visibility.
if we get the email ID, we can send and we can come
We were
across.
not able to communicate with him.
But
He
he's
was not responding.
But the petitioner is techno-savvy. He can, if the order is downloaded in the server, he can go through it. My lord.
So the, in the, on Friday. Stop the, in the meantime, a petitioner will intimate his email address to the respondents, Google India, as well as respondent number 4 and 5
In fact.
on Friday.
Deeply.
Friday morning.
Obliged, my lord.
I came 19, and I will 20 orders 25.
Other side.
But this can be taken up. But again, I'm saying this can be taken up during this circuit, but not today, Lord. It's already 3. I'm ready with the matter, no? I can start with it. I can start with it.
Not choose to file the reply.
Based on material good.
So let there be a.
I'm taking up the matter, entire matter is not taking it.
Tomorrow.
He will not file the
Tomorrow.
reply.
Tomorrow.
You have consumed everything that you have in your life. And not today.
Not good, just all.
Shall we go?
After that, item 1, there are 44,000. For this case, I'm
Filing my matter, yes. State review.
My lord, hearing my sense, the toughest appeal for the petitioner, my lord. My lord, hearing the petitioner is praying for a very innocuous prayer, my lord, for speed disposal.
I am not standing in the way. Let there be a direction upon the trial court to dispose of the matter within a year.
The charging from separate sheet and the content will charge and the right.
My lord, can you appreciate that the charge was claimed on 10th February 2021, my lord?
2021.
2021.
And how many
And
witnesses examined?
Not a single witness.
My lord, I don't want to enter with the merit because it will hurt my brother also. Thrice the de facto complainant appear, thrice they pray for time.
You are for the accused.
Accused.
They are for the accused.
And you have been taking representations under section 317.
And my lord may kindly come to page number 12, order number 10.
Deprecates such directions or time bound act.
My lord, a direction will be given to conclude the trial within a span of 1 year or 1.5 years, my lord.
So I give the directing CBI to examine the witness on day basis and conclude. This is the direction you are seeking against the CBI.
My lord.
They have not been producing.
No, thrice the de facto complainant appeared, my lord, before the trial court. They prayed for time.
No, one on the.
I can take my lord to the orders. I can take my lord to the orders. It is there in the order sheet.
And you never absented.
No,
When altogether 13 dates were given for examining of the witness, my lord. On the 2 occasions, my senior was not in his station, my lord. For that reason, we have taken leave for adjournment.
And on the
But
last occasion, the de facto complainant surrendered before the court, requesting the court to wind up the matter.
against the witness.
Revisional application.
We have under command 482 of the
482.
482 of the set.
This is an application under section 482 of the Code of Criminal Procedure. It has been. That's fine. It has been submitted on behalf of the petitioner that the the petitioner was arrested and subsequently released on bail in connection with the case being RC 121 of 2008. Okay. Later on. The charge sheet was filed by the respondent, Central Bureau of Investigation, and charges stood framed against the writ petitioner on February 10, 2021.
My lord,
It is further submitted that since then, almost 13 dates were fixed in the case. But how many witnesses have been examined? None.
Not a single witness, but
But,
the de facto payment has to be examined first.
but, no witness has been examined by the prosecution till date. So, in such circumstances, it is great on behalf of the petitioner that the direction be issued from the 11th trial court to dispose of the case in a time bound manner. From the next trial court, an advocate representing the Central Bureau of Investigation submits that the de facto complainant appeared before the 11th trial court for his deposition, but the evidence could not be recorded on the said date due to absence of the writ petitioner.
my lord.
So he further submits that the delay in the trial cannot be attributed to the investigating agency only. So the writ petitioners are also contributing to such delay. Next paragraph. Having considered having heard the submissions, meeting the parties and consideration of the materials placed with the instant read applications and should be appropriate. If the writ petition be disposed of with a request to the Lana trial court to dispose of the pending case being RC number.
Special case number 06, Your Honor. My lord.
Special case number 06 of
2018.
2018. As early as possible without providing any unnecessary adjournments to any of the parties. The preferably within 6 months from date.
Let it be 1 year, my lord, because few of the witnesses are from
How
mainland.
many witnesses?
This they have not enclosed, so I don't know, like.
So you charge sheet, you are the charge sheet.
I am not the trial advocate before the court below. I am before only for this honorable court.
Within a year from the date of communication of this order.
Grateful, my lord.
Consequently, WPA, CRR is disclosed of.
Okay.
For the petitioner. Here, your lordship, the petitioner is a tenant. He is a tenant. He filed a suit for illegal protection against illegal eviction and declaration of tenancy. During the pendency of the suit, your lordship, the petitioner filed an application under Order 39 Rule 7.
Which for the other side?
Service has been effective, your lordship.
Direct deposit on addressee instructions. What does it mean?
The instructions of the addressee might sometimes call the postman and ask him to deliver it at this particular place. That has happened.
And it was done on 31st of July.
Yes,
Today we are on 3rd,
four.
4th. And where is the address? The respondent?
Dairy farm, nearby. Dairy farm.
He's the landlord. He's the landlord.
Yes,
You are the tenant.
yes. I wanted to get the premises repaired because when I was absent from the place concerned, I had been to mainland for some of my treatment. Some tins, that is the roof, that was there above the kitchen, that is the roof of the kitchen, that got damaged.
And why that prayer has been rejected?
Your Lordship, the court is asking me to file an application under order 26. Not specific, but basically
Order
that.
26, that is for local investigation.
What is the requirement of that, Your Lordship? I am just asking for replacement of the tin roof. And he is asking me to.
Maybe Mr. Japal will be appearing tomorrow. No. Let it be tomorrow. Let us see.
Yes, sir.
It will not be good to pass an order behind the back of the.
Yes, sir. Let it be tomorrow. I am for the petition.
You are for the petition. And who is for the other side?
Nobody's appeal service has been affected, Your Lordship, government authorities.
You have done today something. Your side is not appearing. It is you only.
This case, Your Lordship, here what happened, the conditional order was
And
passed.
where is the affidavit of service?
Yes, it's
Yes.
filed. Your Lord.
Any private respondent?
No, Your Lordship. So only the government authority.
Where is the madam?
Yes.
She usually appears.
Usually appears, Your Lordship. Today,
Come back to me.
yes.
Both the councils are mother and son. They deserve someone.
Still in the making.